rages on.
All right, we have some big breaking news coming in. The Karnataka High Court that took up the hearing at 2:30 p.m. Had a lot of deliberations on whether or not hijab is an essential practice in Islam. And furthermore, in fact, we heard arguments over the confusion right now that prevails at several educational institutions on whether or not to allow girls with hijab inside classrooms. Karnataka government, meanwhile, has distanced itself from the hijab showdown. It's now put the onus on the College Development Committee for uniforms of students. During the hearing in the Karnataka High Court, the Karnataka government has said that they have not taken any decision and do not wish to intervene in the uniform face-off. Representing the government in court, the Advocate General has said that the government is being dragged into the issue unnecessarily. Now, this is the words of the advocate representing the government, saying that the government does not want to intervene in this face-off. It's all left to the College Development Committee for them to decide whether to allow or not. Cutting across to Nolan Pinto. Nolan, as much as the government now distances itself, the scenes and sights that we see across all government institutions in Karnataka is sorry and pitiful. Many of them never had a CDC guideline that banned hijab and now have all of a sudden taken a U-turn, have restricted all those girls right outside gates weeks ahead of examinations. This confusion, this miscommunication has led to all of these girls' future now hanging in balance. What has happened in court?
Well, in fact, first of all, today the Advocate General has come out with his submissions finally after a very long time. And he has clearly stated basically that hijab is not an essential religious practice of Islam. In fact, he came out with 3 submissions. Very quickly, I will take our viewers through it. He says, my first submission is that the order is in consonance with the Education Act. That's the government order that was passed by the Karnataka government stating that one can't wear religious attires while entering a classroom. He says, second is the more substantive argument that hijab is an essential part. We have taken the stand that wearing of hijab does not fall within the essential religious practice of Islam. And finally, he says, third is that right to wear hijab can be traced to Article 19(1)(a). He says submission is that it does not do so. So basically, he has been arguing on these three major issues, and also that it is the college development committees, like you rightly stated, that will take a call. There was also an argument on the composition of a CDC about an MLA being part of it, whether it has any statutory basis, because earlier on the petitioners' advocates had stated that the CDC does not have statutory basis, and he has been stating that this is a circular, yes, issued by the Undersecretary, but has the backing of the government of Karnataka. So as of now, the hearing has concluded.
Right.
It will resume on Monday, Nabila.
Right. Thank you.